Engross Second Substitute Senate Bill 5051. Clerk will read.
An act relating to state
Last
oversight, release, and use of such information provided.
With the consent of the House, we will not adopt the Public Safety Committee amendment. The Appropriations Committee amendment is before us for the purpose of amendment. The following amendments have been withdrawn. Amendment 593 and 617. Amendment 604. Clerk will read.
On page 4, beginning
line.
on line 15, insert clear, cogent, and convincing.
Member from the 19th District, Representative Walsh.
Thank you, Mr. Speaker. Please move Amendment 604.
It has been moved and seconded that Amendment 604 be adopted. Remarks. Representative Walsh.
Thank you, Mr. Speaker. This amendment improves some language in the underlying bill that has to do with the standards of proof that would be used in the processes and procedures of potentially decertifying law enforcement officers in the state. The underlying bill uses a very low standard of proof in these procedures. And what the amendment does is it adds a higher standard and a better standard, in my opinion, to those processes. And as the last line of the amendment read, that higher and better standard is that the proof in a situation, in a case, has to be clear, cogent, and convincing. This is important, Mr. Speaker, as the actions considered by these procedures have the potentially have the effect of ending careers, even negatively affecting lives. So we should not take these matters trivially, Mr. Speaker. We should use a high and demanding standard of proof when considering such allegations. Let's do well by the general public, and let's do well by the law enforcement community by requiring a high and rigorous standard of proof. This helps everyone. Please vote yes.
The member from the 5th District, Representative Ramos.
Thank you, Chair. Speaker Lovick. I respectfully request a no on this amendment. The use of a preponderance of evidence is the standard used in most civil situations. That is the standard used throughout many agencies, and it's used in administrative investigations as well. As a normal standard. As an example, the Nurses Association, they use a preponderance of evidence as well in their administrative investigations. I see no reason to have a different standard than the norm in most of these investigations. And law officers should be held to this standard as they are very important in what they do as equivalent to nurses. So I respectfully again ask for a no on this amendment. Thank you, Mr. Speaker.
The member from the 18th District, Representative Huff.
Well, thank you, Mr. Speaker. I just want to disagree with the good gentleman from the 5th. The evidentiary standard that we're talking about is a difference between preponderance and clear and convincing. In an earlier piece of legislation that dealt with first our frontline heroes, we agreed, or this body agreed, that the higher standard was appropriate. Clear and convincing carried the day. Well, Mr. Speaker, if clear and convincing carries the day for a presumptive disease, it certainly should carry the day for decertifying one of our law enforcement officers. Please approve this amendment.
Member from the 45th District, Representative Goodman.
Thank you very much, Mr. Speaker. Once again, the preponderance standard is used throughout administrative proceedings, similar to what is considered in this bill. And there's an important distinction between the clear and convincing standard for a contraction of a disease, where that's the harm to the individual, as opposed to the standard for a police officer harming somebody else. The stakes are so high here that it's important that the threshold be reasonable to hold the officer accountable for misconduct because of the power that the officer has in the community. Also bear in mind that decertification, the removal of the license, is only one option. The bill and this proposal has a range of options, including probation and suspension and reprimand and training. And this preponderance standard would trigger any of those to correct the misconduct and the bad behavior. So recommending a no vote.
The member from the 19th District, Representative Walsh.
Thank you, Mr. Speaker. I just need to unravel this logic pretzel. If the stakes are high, the standard of proof should not be low. If the stakes are high, the standard of proof should be high. Please vote yes.
Further remarks? Seeing none, the question before the House is the adoption of Amendment 604. The Speaker will divide the House. The Speaker is about to open the roll call machine. The Speaker has opened the roll call machine. Has every member voted who wishes to vote? The Speaker is about to lock the roll call machine. The Speaker has locked the roll call machine. The clerk will announce the totals, please.
Mr. Speaker, there are 41 yeas, 51 nays, 1 excused.
The amendment is not adopted. Amendment 603. Clerk will read.
On page 4, beginning on line
Last line.
23, those certified under Chapter 70.96A RCW.
The member from the 31st District to move adoption of the amendment, Representative Robertson.
Thank you, Mr. Speaker. I move Amendment 603.
It has been moved and seconded that Amendment 603 be adopted. Remarks, Representative Robertson.
Thank you, Mr. Speaker. This is truly a technical amendment. I think inadvertently, some of our specially commissioned peace officers, limited authority peace officers, the higher ed security officers, as well as our K through 12 security officers were placed as a subset of a reserve officer in the definition section. And so to remedy this, Mr. Speaker, we've taken those 4 areas, the specially commissioned police officers, which are have a limited authority, a special commission, like a prosecutor's investigator, a traffic enforcement, parking enforcement, and reserve officers are indeed a specially commissioned officer, as well as some of our peace officers in our neighboring states who have a cross-jurisdictional commission. And then our limited authority officers, which are our liquor and cannabis board officers, gambling commission, Department of Natural Resource investigators and such. We take those out of the definitions, but we make sure that they're placed in the section which they are intended, which is in the area in which they are required to go through a background and check, including fingerprinting by the Washington State Patrol, as well as the FBI fingerprint center. So the first section takes them, corrects and removes them from the definitions. It puts them back in the 2 subsections. And then the final section, section 39, really focuses on the condition of employment for both our K through 12 folks that are hired for security purposes, as well as the higher ed officers that are hired for security, to ensure that they are also gone through an entire background check. And so that is the culmination of a bunch of moving pieces, yet another pretzel in this bill, and I urge your support.
The member from the 45th District, Representative Goodman.
Thank you, Mr. Speaker. If you didn't understand what the gentleman from the 31st was just describing, join the club. I'm about to describe something even more complicated.
Would the member please not impugn members and speak to the amendment in front of you? Please proceed.
I'm sorry, Mr. Speaker. I was just making light of that. I'm about to be even more obtuse. This issue, I had a lengthy conversation with a gentleman from the 31st before this floor debate about this amendment, and I've been struggling mightily to accept it. But there are a couple of issues. The point of the definition of reserve officers in this bill is to ensure that reserve officers who are called into duty as if they are fully commissioned officers with a gun and a badge enforcing the criminal law, that they, despite being reserve officers, should be subject to the provisions of this bill. And that's the reason the definition section, the definition is in the section of the bill. The definition of reserve officers in this bill is exactly the same, word for word, as the definition in Washington Administrative Code 139.05.810. So by this amendment actually moves half of the definition into another section, thereby creating an inconsistency in the definition in law between rule and statute. The other problem is that the educational officers in higher ed and K-12 would be receiving not the same background check, not the same rigorous background check, and we want all of the peace officers to be receiving the same robust background check. And finally, this is such a confusing matter as to who are all of these, what are all of these categories of reserve officers, limited commission, general commission, specially commissioned, and so forth. There's another amendment coming up to require the Criminal Justice Training Commission to report back to the legislature and clarify all of this. So for the moment, I respectfully request not adopting this amendment, and we're going to have to sort this out in the next year. Thank you, Mr.
Further remarks? Member from the 31st District, Representative Robertson.
Thank you, Mr. Speaker. I understand that perhaps the WAC has one definition, but I just point the good gentleman to RTW 10.93.020, which goes into extensive detail as to the definitions of.
The member has less than 30 seconds remaining. Please proceed.
It specifically outlines the specially commissioned police officers, limited authority peace officers, higher ed security, and K through 12, and has the reserve officer as a subset of the specially commissioned officers. I urge your support. Thank you, Mr. Speaker.
Member from the 8th District, Representative Clippert.
Thank you, Mr. Speaker, and I greatly appreciate the gentleman from the 45th speaking up, and also thank the gentleman from the 31st for his comments. So taking particularly attention to the gentleman from the 45th comments, Mr. Speaker, if this part of this bill that has such very high stakes is so confusing, does it not make sense that this part of this bill not be passed into legislation as written? Strongly encourage that this amendment be adopted. Thank you, Mr. Speaker.
Further remarks? Seeing none, the question before the House is the adoption of Amendment 603. The Speaker will divide the House. The Speaker is about to open the roll call machine. The Speaker has opened the roll call machine. Has every member voted who wishes to vote? The Speaker is about to lock the roll call machine. The Speaker has locked the roll call machine. Clerk will announce the totals, please.
Mr. Speaker, there are 37 yeas, 54 nays, 1 excused.
The amendment is not adopted. Amendment 602. Clerk will read.
On page 13.
Last line.
Internal references accordingly.
Member from the 16th District, Representative Rood.
Thank you, Mr. Speaker. I move adoption of Amendment 602.
It has been moved and seconded that Amendment 602 be adopted. Remarks? Representative Rood.
Thank you, Mr. Speaker. May I read from the effect statement, please?
Please proceed.
Thank you. This amendment removes review of an applicant's social media accounts as part of the background check requirement for peace officers, correctional officers, and reserve officers. Removes the requirement that a peace officer or a peace or corrections officer consent to and facilitate a review of the officer's social media accounts as a condition of certification. What I think is interesting is that the bill does not have a definition for social media. And so I looked up the definition, the dictionary definition, if I may read again, Mr. Speaker.
Please proceed.
It includes websites and applications that enable users to create and share content or to participate in social networking. I'm probably going to date myself, but I think many of us think of social media as Facebook and Twitter, maybe Instagram. Many of these have built in, there's a kind of a public-facing side of the application or the website, and most of them have built-in messaging service as well, where I know that I use Facebook Messenger frequently, and may have conversations that I don't want future employers to see. There are other applications like dating applications like Tinder and others that are kind of their own class that are strictly messaging. And so I think it's a very, very broad definition. And this day and age, I mean, we're all operating virtually at this point. People are using these services to communicate with each other and potentially sharing information, maybe personal health information, legal information that they would prefer not to share. So I think it's also important to note that most of these services, some are app-based, but some of them are also websites. And if we were to try to catalog them, I think we'd find that very challenging.
I see a little clock.
So I think I appreciate where we're trying to go with this.
Member has about 30 seconds left. Please proceed.
Thank you, Mr. Speaker. I appreciate where this is trying to go, but ultimately these can be deleted at any time. And for those who are trying to hide information, I don't think it's effective, and we end up invading the privacy of applicants. So I'm urging support of the amendment.
The member from the 30th District, Representative Johnson.
Thank you, Mr. Speaker. I'm respectfully asking for a no vote on this amendment. This is an emerging important aspect for all background checks in many fields of work. As public servants, just like you and I, Mr. Speaker, we are responsible for what we post. As the good gentleman from the 16th mentioned, this is the day and age we're living in. And beliefs lead to expressions, which can often lead to actions. For example, it's important to know that our officers have not posted messages on social media that may convey messages of bias or malice towards a group of people. And that's vital to maintain public trust and confidence in our law enforcement. Furthermore, this is particularly important in keeping racists and other extremists out of our law enforcement agencies. Someone who espouses racist views is fundamentally incapable of morally or impartially enforcing the law. So again, I'm strongly urging a no vote on this amendment.
The member from the 25th District, Representative Chambers.
Thank you, Mr. Speaker. I urge adoption of this amendment. There's some stuff that, like the good gentleman mentioned from the 16th, that can be shared with, personal messaging apps that convey information that it would be illegal for an employer to ask about when interviewing and searching for a candidate to hire. It would not be legal to ask on a job application whether you own or rent your home. And if you're using an app to communicate with your realtor or somebody searching for a place to live, then you're bringing information that's coming into conflict with your some rights that are already protected for workers looking for jobs and boundaries that have been set for a long time. So I think you're wading into murky areas here by bringing social media into the job applicant process. Urge adoption of this amendment.
The member from the 39th District, Representative Sutherland.
Thank you, Mr. Speaker. I rise in support of this amendment. We've heard tonight we're opening up someone's social media. While the intention is good, we want to see who this person might be that we might be hiring. Employers aren't authorized to know everything about an individual. And too many times on social media, we talk about our closest, most personal and information with our family and our friends. But what caught me about the testimony just a few minutes ago was, it was mentioned that, we want to see if someone is, potentially biased against a certain group, but who makes that decision? We heard testimony tonight that by a school asking a child to sign a form to see if they were
The member please speak to the amendment in front of you, Amendment 602. Please proceed.
Yeah, thank you, Mr. Speaker. Again, I'm in support of this amendment. Thank you.
Further remarks? Seeing none, the question for the House, the adoption of Amendment 602. The Speaker will divide the House. The Speaker is about to open the roll call machine. The Speaker has opened the roll call machine. Has every member voted who wishes to vote? The Speaker is about to lock the roll call machine. The Speaker has locked the roll call machine. Clerk will announce the totals, please.
Mr. Speaker, there are 40 yeas, 49 nays, 1 excused.
The amendment is not adopted. Amendment 614, clerk will read.
On page 14, beginning on
Last line.
rules of.
The member from the 26th District to move adoption of the amendment, Representative Young.
Thank you, Mr. Speaker. I move Amendment 614.
It has been moved and seconded that Amendment 614 be adopted. Representative Young.
Thank you, Mr. Speaker. Recommending a yes vote. This amendment provides that statutorily required background tests or assessments must be administered in compliance with standards established by the CJTC. Recommend adoption. Thanks.
Further remarks? The member from the 45th District, Representative Goodman.
Thank you, Mr. Speaker. I want to thank the gentleman from the 26th for bringing this amendment again. He brought it in committee and I didn't quite understand it, so I apologize for that. I do agree that it should be statutory. It should be up to the legislature to determine background tests and assessments and not left up to rule by the Criminal Justice Training Commission, which could interfere with what local agencies may be doing. So I concur and wish that we accept this amendment.
Further remarks? The question before the House is the adoption of Amendment 614. The Speaker will divide the House. The Speaker is about to open the roll call machine. The Speaker has opened the roll call machine. Has every member voted who wishes to vote? The Speaker is about to lock the roll call machine. The Speaker has locked the roll call machine. The clerk will announce the totals, please.
Mr. Speaker, there are 83 yeas, 6 nays, 1 excused.
The amendment is adopted. Amendment 600. Clerk will read.
On page 16.
Last line.
Strike must and insert may.
The member from the 9th District, Representative Dye.
Thank you, Mr. Speaker. I move Amendment 600.
It has been moved and seconded that Amendment 600 be adopted. Remarks, Representative Dye.
Thank you, Mr. Speaker. You know, I've learned something from you that was really important when we first had an opportunity to get to know each other when I was just new in the House of Representatives. And it was a great honor to get to know you. And you said something about the institution of the state legislature and how important it is to respect that institution. And when you're at the gavel, you like to be prompt and you manage that gavel and your role in this honorable institution with a great deal of respect for the institution. And when it comes to law enforcement, you having served also in law enforcement and you put on the uniform, I can imagine that wearing that uniform is a form of respect to the institution of law enforcement. This amendment is a may must amendment. So right now, the bill before us suggests that the commission would have a must employ these prescriptions for people who have done a litany of bad behavior. And it's heartbreaking to me to have in statute this long litany when you know that the men and women who put on that uniform and wear the accoutrement and the tools of the trade are representing the institution of our law, the laws that we write here on this body, the laws that you are also wearing the uniform to enforce. And it's a two-way interaction between the public and law enforcement. and the respect for the institution is a two-way street. It's a relationship. And I would also say, Mr. Speaker, that there are many places in law enforcement where you have relationships with your supervisors and with the organizations with which you serve. And those also know whether or not the men and women that they have hired are holding in high regard the institution of law enforcement and the uniforms that they wear. And I think that they would be aware. And I think that we should put a may instead of a must, because there must be both local discretion and greater discretion at the higher level. And I think that
The lady has 30 seconds remaining. Please conclude.
Thank you, Mr. Speaker. So in this bill and in this amendment, it allows a broader source of authority to make important evaluations as to whether or not the men and women that are wearing the uniform that represents the institution of both the laws that we make and that the laws that they retain and enforce.
The lady's time is up. The member from the 30th District, Representative Johnson.
Thank you, Mr. Speaker. Words matter, and we're not supportive of narrowing the scope of this bill. And this amendment actually undermines the whole point of accountability we are trying to accomplish, which is a must. The underlying bill states that all mandatory decertification requires judicial finding or employer termination. There is, in fact, some conduct that is so egregious that the conduct warrants mandatory decertification. And if the officer is convicted of a felony or sex offense, they should probably be decertified. If the officer was terminated by their employing agency for excessive use of force, they should probably be decertified. Or if the officer has knowingly made misleading or deceptive or fraudulent reports as an officer, they should probably be decertified. And so that's the definition of accountability. And that's what this bill is doing, is putting accountability into law. And so asking for a no vote on this amendment. Thank you.
The member from the 8th District, Representative Clippert.
Thank you, Mr. Speaker. I thank the good gentleman who just spoke for his comments. I don't want to jump ahead in amendments or testimony, but the comment was just made about conviction of a felony. And when you read the language of the bill, it actually says without regard to conviction. Mr. Speaker, what this amendment simply says is we don't want to require the Criminal Justice Training Commission to decertify or revoke certification or suspend the certification of a law enforcement officer. We want to allow them to. We don't want the heavy hand of the legislature telling the criminal justice system what finding they must make. What this amendment says is allow the Criminal Justice Training Commission to make their finding without us mandating it. And we'll talk more about this as we go on in amendments and final passage. So please vote yes on this amendment to allow the Criminal Justice Training Commission to do their job rather than requiring them to do what we tell them to do. Please vote yes on the amendment, Mr. Speaker.
The member from the 45th District, Representative Goodman.
Thank you, Mr. Speaker. I think it's important to make the distinction in this bill between those patterns of conduct which call for mandatory decertification, and in another part of the bill, the conduct which calls for the discretion by the Criminal Justice Training Commission to either decertify or impose other lesser sanctions. As far as the mandatory decertification, it's actually not a long list, but it is extremely serious conduct. And this bill states our policy that if you are convicted of a felony, if you are convicted of domestic violence offense, if you're not permitted to possess weapons, if you have been terminated for excessive use of force, if you have been terminated for fraud or misrepresentation, you should be decertified. And I agree with that policy. And I think the language should be left alone in this bill, and therefore we should not adopt the amendment.
Further remarks? Seeing none, the question before the House is the adoption of Amendment 600. The Speaker will divide the House. The Speaker is about to open the roll call machine. The Speaker has opened the roll call machine. Has every member voted who wishes to vote? The Speaker is about to lock the roll call machine. The Speaker has locked the roll call machine. Clerk will announce the totals, please.
Mr. Speaker, there are 37 yeas, 53 nays, 1 excused.
The amendment is not adopted. Amendment 597. Clerk will read.
On page 18,
Last line.
Committed.
The member from the 25th District, Representative Chambers.
Thank you, Mr. Chair. I move Amendment 597.
It has been moved and seconded that Amendment 597 be adopted. Remarks, Representative Chambers.
Thank you, Mr. Speaker. This amendment provides that if an officer were to be decertified for sexual harassment, that it be following an investigation into an allegation of sexual harassment. Given that this would be a career-ending finding, I think it's important that a proper investigation be done. And this would be similar to what most employers would do in an investigation of the same type. You don't just take somebody's word on it. You investigate the situation before making any decisions as to how an employee guilty of such harassment should be dealt with. I ask the body's adoption. Thank you.
The member from the 45th District, Representative Goodman.
Thank you, Mr. Speaker. Thanking the gentlelady from the 25th for bringing this topic before us. There are a couple of reasons why I believe we should not adopt this amendment. The first is that, as a matter of course, an investigation is going to take place. If there are allegations of sexual harassment or any other misconduct, it would be brought to the attention of the Criminal Justice Training Commission. They would initiate an initial screen if it looked serious, and if so, then proceeding to an investigation. And if the investigation found anything, then holding a hearing, and based on the hearing, perhaps the imposition of sanctions. This is the process that will be undertaken for any of the possible areas of misconduct. The problem with this amendment is that by specifying that in cases of sexual harassment, there be an investigation, what about other areas of misconduct? Does this mean that investigation would not have to take place? There might be a question of statutory construction there, that there be this inconsistency. So I have confidence that investigations will take place in incidents like this and other incidents of misconduct, because otherwise the Commission wouldn't have the information upon which to take action. So I respectfully ask we not adopt this amendment.
The member from the 8th District, Representative Clippert.
Thank you, Mr. Speaker. Well, you don't have to watch very much news today, and you find that there are, in fact, very high-profile elected officials who have allegations, many allegations of sexual harassment. And those very high-profile elected officials are saying, conduct an investigation. I did not do it. So all this amendment says is just like a high-profile elected official would ask for, is there be an investigation and an actual finding that sexual harassment has taken place, not just accusations of sexual harassment. This is a good amendment. This is a sound amendment that simply asks for an investigation and a finding that sexual harassment actually took place. Please vote yes, Mr. Speaker.
Further remarks? Seeing none, the question before the House is the adoption of Amendment 597. The Speaker will divide the House. The Speaker is about to open the roll call machine. The Speaker has opened the roll call machine. Has every member voted who wishes to vote? The Speaker is about to lock the roll call machine. The Speaker has locked the roll call machine. Clerk will announce the totals, please.
Mr. Speaker, there are 38 yeas, 52 nays, 1 excused.
The amendment is not adopted. Amendment 598. Clerk will read.
On page 18.
Last line.
Felony strike without regard to conviction.
The member from the 20th District, Representative Arbarno.
Thank you, Mr. Speaker. I move Amendment 598.
It has been moved and seconded that Amendment 598 be adopted. Remarks, Representative Arbarno.
Yeah, thank you, Mr. Speaker. This amendment attempts to restore due process and clear up a vague contradiction by removing language in Section 9. There's two subsections there that contradict the words "without regard to conviction" as it applies to whether law enforcement officers have been convicted of a felony without regard to that, or have been found versus convicted. Mr. Speaker, I believe we all deserve due process under law, and we all should be considered innocent until proven guilty. This session, I've watched holes poked into both those fundamental rights and tenets, and I hope that this amendment helps patch up this bill's. Section 9, subsection 2 of this bill would allow for the denial or revocation of a certification if an officer were convicted of a felony. But then in Section 3, the section right after, or subsection 3 in Section 9, it engulfs the entire language of subsection 2 with the words "without regard to conviction." So one section says you have to have a conviction, the other says without regard to conviction. So there's a conflict there. And with my amendment, if a felony was committed, revocation or denial of certification will happen as stated in subsection 2. That's left unchanged. But what this amendment does, Mr. Speaker, is remove the language that would strip the law enforcement officer of their due process rights when no felony conviction actually occurred. It removes the language that gives discretion to the commission to revoke or even refuse certification for something that doesn't even rise to the level of a felony conviction. You know, as you know here, the loss would be substantial, and the fundamental right of due process rises to a higher review standard. It is clear and convincing. With the lower standard of preponderance that's in this bill, it should at least be required that the case be adjudicated with that higher level, at least in a criminal standard, which would be beyond reasonable doubt. Certification is revoked or denied when there is a felony conviction, like robbery in the first degree, a serious crime. Not an act that might or might not actually rise to the level of a felony conviction. This legislation chips away at the due process rights of our peace officers. So the question is, where does that end?
The member has 30 seconds remaining. Please conclude.
Thank you, Mr. Speaker. Hopefully, the passage of this amendment can slow down this bill's damage and what I believe is the weakening of our law enforcement community and public safety structure. Mr. Speaker, I'd ask for a yes vote.
The member from the 11th District, Representative Hackney.
Thank you, Mr. Speaker. I appreciate the concerns about due process raised by the good gentleman from the 20th, but I must urge a no vote on this amendment. Mr. Speaker, we should not require a felony conviction for discretionary decertification. The bill already requires mandatory decertification for a felony conviction. There are numerous ways, both negligently and intentionally, to sabotage a felony criminal conviction. The focus should be on the law enforcement officer's conduct, not the felony conviction. For criminal convictions, we have a higher standard of proof beyond a reasonable doubt because defendants have rights protected by the United States Constitution. There is no constitutional right to be a law enforcement officer. The appropriate standard of proof to determine whether there was professional conduct is preponderance of the evidence. And for those reasons, Mr. Speaker, I urge a no vote on this amendment.
The member from the 19th District, Representative Walsh.
Thank you, Mr. Speaker. This is a good amendment. Please vote yes. The amendment clears up something that is endemic throughout the underlying bill, which is a shifting focus from criminal standards of proof to civil standards of proof. And then within both of those categories, shifts around within standards of proof that are used in each. It is slippery stuff, Mr. Speaker. It's poorly drafted. And this amendment does clean up a little bit of that slipping and sliding around in the standards of proof. It helps. Please vote yes.
Further remarks? Seeing none, the question before the House is the adoption of Amendment 598. The Speaker will divide the House. The Speaker is about to open the roll call machine. The Speaker has opened the roll call machine. Has every member voted who wishes to vote? The Speaker is about to lock the roll call machine. The Speaker has locked the roll call machine. Clerk will announce the totals, please.
Mr. Speaker, there are 37 yeas, 51 nays, 1 excused.
The amendment is not adopted. Amendment 619, clerk will read.
On page 19.
Last line.
Strike to place on probation.
The member from the 35th District, Representative Griffey.
Thank you, Mr. Speaker. I move Amendment 619.
It has been moved and seconded that Amendment 619 be adopted. Remarks, Representative Griffey.
Thank you, Mr. Speaker. This amendment removes the ability for the Criminal Justice Training Commission to put a member that serves under that purview on probation. Mr. Speaker, every public safety worker that I know of in Washington State serves under collective bargaining agreement. That collective bargaining agreement and the rights there within give the workers in Washington State the right to bargain wages, hours, and working conditions. And part of that working condition, Mr. Speaker, is what it takes to work at the organization, what professional standards it takes, and how, if, and when you are suspended or terminated from your employment. With the makeup of the underlying bill being weighted so in favor of away from law enforcement or those members that have good ideas about what the law enforcement profession entails, our men and women in law enforcement need their collective bargaining rights protected now more than ever. So we should respect the collective bargaining unit rights of every Washington worker and not allow this bill to supersede collective bargaining rights that have been so hard won and so hard fought and won by every worker that has a contract in Washington State. I strongly urge the adoption of this amendment. Thank you, Mr. Speaker.
The member from the 5th District, Representative Ramos.
Thank you, Speaker Lovick. Respectfully requesting a no vote on this amendment. You know that when we look at this, we need to have graduated sanctions. We're looking for accountability here. We're not looking to be destructive. So as you look at someone's mistake and the JTC investigates and comes up with a finding, we need to be able to have a finding that is action that is responsible with that finding. So if we have only the option of doing nothing or decertification, it leaves the JTC with nothing to, we can lose good officers that with a little bit of training or suspension or probation where they get back in line and become a good officer for the rest of their career is a great thing to do. I don't know any employment situation where if you make one mistake, your option is decertification, losing your job versus getting the training you need to improve and get back on track. So we need these options so that suspension, probation, additional training, whatever is required to get that officer back on track is available for use, not just a black and white result. Please vote no. Thank you.
The member from the 7th District, Representative Maycomber.
Thank you, Mr. Speaker. I appreciate this amendment. I appreciate what the good gentleman from the 5th said. However, we are not going to be losing good officers after this bill passed. We're losing good officers every day. We're losing good officers every moment. You have a collection of bills that weaken the collective bargaining agreements of these good people that have risked their lives every single day for you and me. That have put their lives on the line, that have the collective bargaining agreement that says they can go to a mediator, a neutral party that may be through the process, but now a CJTC Citizen Commission now will make a determination outside of a workers' union agreement. Mr. Speaker, this is a very, very, very important amendment. This is a very important point in this policy where we make the decision that a collective bargaining agreement, one of the most valued things in the state of Washington, one of the most valued things for the workers that they have had, that says that they are following the training that has been provided for them and they are doing what they have agreed to do, will now be null and void due to a citizens commission that has not gone through that training, that has not put their life on their line, that does not understand what is occurring on the streets, will now make the determination against what they have agreed to. Once you take away that local control, once you take away that collective bargaining agreement, it is now not sacred anywhere. This is in a contract, an agreement that says if you do what you have been trained, if you do what you have agreed to do, you will go through the process, and that is with an arbitrator and a neutral party. And that is the agreement, and that is the agreement the state of Washington has made with our unions, that they are sacred. Mr. Speaker, please do not touch this and do not put a citizens commission above this agreement. Please vote yes.
The member from the 45th District, Representative Goodman.
Thank you, Mr. Speaker. I had been quite concerned about collective bargaining rights. I'm very, very strongly supportive of collective bargaining. And so I did put language in this bill that made sure that an officer on probation or who is suspended may not be terminated by the local agency just because of the suspension or the probation. And that language remains in the bill. There have been, however, excesses or injustices where officers who have been fired for serious misconduct have, under their collective bargaining agreements, arbitrated the discipline and then been rehired despite their misconduct. And that's one of the purposes of establishing this new scheme, is that there would be a backstop on the state level for insufficient or lack of action on the local level. There would be concurrent jurisdiction, but we are not going to see the Criminal Justice Training Commission interfering with local control, only making up for the lack of local accountability. And so for that reason, and for the reason that probation is an important intermediate sanction, and those who are on probation will not be able to be terminated, we would not want to accept this amendment. Thank you, Mr. Speaker.
Further remarks? Seeing none, the question before the House, the adoption of Amendment 619. The Speaker will divide the House. The Speaker is about to open the roll call machine. The Speaker has opened the roll call machine. Has every member voted who wishes to vote? The Speaker is about to lock the roll call machine. The Speaker has locked the roll call machine. Clerk will announce the totals, please.
Mr. Speaker, there are 36 yeas, 51 nays, 1 excused.
The amendment is not adopted. Amendment 583, clerk will read.
On page 25, request consultation with the Commission.
The member from the 40th District, Representative Lekanoff.
Mr. Speaker, I move 583.
The member from the 40th District to move adoption of the amendment, Representative Lekanoff.
Mr. Speaker, this is a very simple amendment. It requires and clarifies.
It has been moved and seconded that Amendment 583 be adopted. Remarks, Representative Lekanoff.
Thank you, Mr. Speaker. This is a very simple amendment, Mr. Speaker, that requests that the Commission have a consultation process to clarify what the requirements are going to be for training for their tribal officers. The training for the tribal officers is a requirement for cross-deputization, excuse me, sir, a late evening for the tribal police officers. Thank you, Mr. Speaker.
Further remarks? The member from the 14th District, Representative Mossbrucker.
Thank you, Mr. Speaker. We concur and ask for a yes on the amendment.
The question for the House is the adoption of Amendment 583. The Speaker will divide the House. The Speaker is about to open the roll call machine. The Speaker has opened the roll call machine. Has every member voted who wishes to vote? The Speaker is about to lock the roll call machine. The Speaker has locked the roll call machine. The clerk will announce the totals, please.
Mr. Speaker, there are 83 yeas, 1 nay, 1 excused.
The amendment is adopted. Amendment 628, clerk will read.
On page 38, after
Last line.
9, internal references accordingly.
The member from the 45th District to move adoption of the amendment, Representative Goodman.
Thank you, Mr. Speaker. I move that the House adopt Amendment 628.
It has been moved and seconded that Amendment 628 be adopted. Remarks, Representative Goodman.
Thank you, Mr. Speaker. This amendment returns to that vexing and confusing topic of reserve officers, limited commission officers, general commission, special commission. What are all of these categories? And so the amendment directs the Criminal Justice Training Commission to report back to the legislature about the different categories of officers and who is going to the Basic Law Enforcement Academy and who isn't, and who should be subject to the training, and also information about the Basic Law Enforcement Academy classes and the backlog and the need for future classes and expansion. So there's actually an important report from the Commission to make sure that we're clarifying the different categories of officers and hopefully expanding the training and accelerating the training. So I encourage adoption of this amendment.
The member from the 14th District, Representative Mossbrucker.
Thank you, Mr. Speaker, and we concur. We appreciate the good gentleman from the 45th for helping clarify the confusing section of the underlying bill. Ask for yes vote.
The question before the House is the adoption of Amendment 628. The Speaker will divide the House. The Speaker is about to open the roll call machine. The Speaker has opened the roll call machine. Has every member voted who wishes to vote? The Speaker is about to lock the roll call machine. The Speaker has locked the roll call machine. The clerk will announce the totals, please.
Mr. Speaker, there are 86 yeas, 2 nays, 1 excused.
The amendment is adopted. With the consent of the House, House Rules 14C is suspended to continue working past 10 p.m. Hearing no objections, so ordered. Amendment 635, clerk will read.
On page 39, after
Last
line 37, state and the provisions of RCW 43.135.060 apply.
The member from the 14th District to move adoption of the amendment, Representative Corey.
Thank you, Mr. Speaker. I move Amendment 635.
It has been moved and seconded that Amendment 635 be adopted. Remarks, Representative Corey.
Thank you, Mr. Speaker, and a very good late evening to you. Appreciate hearing and accepting this amendment tonight. Amendment 635 simply states that the underlying bill would, in fact, create additional regulatory provisions and burdens for state and local governments that would necessitate additional costs. And of course, we're all familiar with RCW 43.135.060 and the importance for us as a state not to provide, if we increase the regulatory piece, to also provide funding for that. Appreciate agreeing to this amendment and urge a yes vote. Thanks.
The member from the 3rd District, Representative Ormsby.
Thank you, Mr. Speaker, and good evening. Respectfully requesting a no vote on the amendment. The fiscal note that came in on this bill was indeterminate, meaning that we don't know how much it's going to cost. We have a rule when it comes to state budgeting and the distribution of our collective resources, and that is that we have to have an idea of what we're buying and what we're paying for. we don't have any idea, but we do send money to local governments for very flexible purposes in the House operating budget for things that come under this title of so-called unfunded mandates, or as we affectionately refer to it around here by its acronym, SCUM. We do provide the ability for local governments with the resources that we send them. And that's what we have supplemental budgets for, Mr. Speaker. We learn about the costs associated with the policies we develop here. We come back and rectify them in the supplemental budget. That would be the appropriate move instead of speculating on unknown costs. Asking for a no vote.
Further remarks? Seeing none, the question before the House is the adoption of Amendment 635. The Speaker will divide the House. The Speaker is about to open the roll call machine. The Speaker has opened the roll call machine. Has every member voted who wishes to vote? The Speaker is about to lock the roll call machine. The Speaker has locked the roll call machine. Clerk will announce the totals, please.
Mr. Speaker, there are 40 yeas, 52 nays, 1 excused.
The amendment is not adopted. With the consent of the House, the Appropriations Amendment as amended is adopted. Hearing no objection, so ordered. There are no further amendments. With the consent of the House, the rules will be suspended and engrossed second substitute Senate Bill 5051 as amended by the House will be advanced to third reading. Hearing no objection, so ordered. Engrossed substitute Senate Bill 5051 on third reading and final passage as amended by the House. Remarks. The member from the 45th District, Representative Goodman.
Thank you very much, Mr. Speaker. This legislation establishes a much stronger state authority to hold police officers accountable for egregious misconduct and patterns of repeated misconduct. The membership of the Criminal Justice Training Commission is altered to have much more of a community voice. The new investigations and hearings and sanctions authority is built up. Background checks for hiring police officers are strengthened considerably. Retention of records are required for a much longer period. And the commission is given the authority to highlight deficiencies on the local level, in particular police agencies. But I want to pause because it sounds like we're beating up on the police all the time. And I want to honor our peace officers for the hard work they do, hoping that they come home safe to their families every night. They're decent, hardworking. They run into the danger for us. It's a job that, well, there are a few of us in the legislature who have taken it, and I honor them, but most of us wouldn't take those risks. The problem is that there are a few officers who engage in misconduct and ruin it for everybody and are cast a shadow on the profession. And for that purpose, we need a mechanism to hold those officers accountable and either remove their license or give them more training or some guidance so that they can get back on the right track. This accountability measure is critical for helping to establish trust between the community and our law enforcement. And again, upholding the police profession so that those who are doing a great job will continue doing a great job, and those who ought not to be in the profession will be removed from the profession. I commend this bill to you and ask for its passage. Thank you, Mr. Speaker.
The member from the 8th District, Representative Clippert.
Thank you, Mr. Speaker. Certainly everyone on the floor of the House of Representatives tonight has the right to vote any way they choose to. I'll be voting no. Mr. Speaker, I went to a meeting at CTAC. I think there was several members of the House at that meeting with me. The keynote speaker was the chief of police of Richland Police Department at that time, and was so popular, he's since moved on to be the chief of police in Eugene, Oregon. In that meeting, as a keynote speaker, he said, we ask law enforcement officers, imperfect people, to go out into an imperfect world and perform perfectly. And he reminded all of us that's much too high of an expectation, to expect imperfect people to go to an imperfect world and perform perfectly. Mr. Speaker, one of the people who represents Washington State Patrol talked to us recently and said, I have something happening that has never happened before. in all my time with the patrol. I have people coming up to me and saying, how soon can I retire? How soon can I get out of this profession? They feel disrespected. They feel with one slip, they're going to be decertified and booted out of the profession that they planned on making a lifetime career because of bills like this. I agree with the gentleman from the 45th. We have great law enforcement officers in Washington State. And I keep hearing over and over and over again, one reason why we need bills like this is because of the conduct of an officer who does not even live in this state. Washington State law enforcement officers are doing a good job, Mr. Speaker. And to hold them at a standard that we don't even hold high-profile elected officials is not acceptable. We should at least hold high-profile elected officials to the same standard that we're asking these law enforcement officers to be held to. And to decertify them without even consideration of conviction, everyone else is presumed innocent until proven guilty. Except for this bill, if you're a law enforcement officer, that standard does not apply. In closing, Mr. Speaker, clear.
Gentleman has 30 seconds remaining. Please conclude.
30 seconds. Thank you, Mr. Speaker. Clear, cogent, and convincing. I looked up the definition of cogent. Appealing to the powerfully to the intellect and the moral standard. That's exactly what we're looking for, Mr. Speaker. Appealing powerfully to the intellect and the moral standard for our law enforcement. Let's stick with clear, cogent, and convincing. Vote no on this bill.
The member from the 14th District, Representative Mossbrecher.
Thank you very much, Mr. Speaker. And unfortunately, I agree with the gentleman from the 45th that these series of bills, the way that they're written, do feel like that the body is beating up on the police officers who are trying to protect us. And I want us to just maybe consider not legislating to the few. There's bad actors out there. We agree. There's not one person that doesn't agree. We have to go after them, and they should not be certified, and they should not be taken from law enforcement agency to agency once they get in trouble. But we're handcuffing the police. We're making it so that they're afraid to do anything. There's a law enforcement agency in the state, in my district, that said, we're going to show up, Representative, but we're not sure how much action we're actually going to take. Because we're afraid we can't do our jobs anymore. People who are making these laws, other than you, Mr. Speaker, are not in the shoes of those who battle this war that we have out there amongst us. The civil unrest, the anger, the frustration, the hatred, things that I didn't see growing up. You know, we used to ride our bikes through the streets in our community and go to the store, and now we just don't let people do that. I don't let my children or grandchildren do that. I worry. I don't take my daughters to Portland anymore to go shopping down by Nordstrom's and those beautiful stores because we can't. It's not safe. Law enforcement protecting those areas for us is not safe. We saw this bill over and over tonight by really great representatives who stepped forward and tried to tell the problems of the bill, to try to further discuss the bill. We saw that due process was at risk, the way that this was written. We saw that there were confusing sections. We saw that drafting issues were in this particular piece of legislation, and that we're circumventing collective bargaining agreements, which undermines the way that the processes need to go in order to keep employees safe. The unfunded mandate piece, we have to address the fact that this is going to hit local government. When we take the power, Mr. Speaker, and we put it all in one agency, from when we make and we allow them to create policy all the way through what you could call execution.
The lady has 30 seconds remaining. Please conclude.
Thank you very much, Mr. Speaker. I hope that we consider this package of bills that's coming forward. And I really wish that we'd had more time to hear from, or to let those people making these decisions, even us making these decisions, do what the good gentleman from the 8th did. Go be part of a training course. to see how difficult this is and to do ride-alongs to understand the difficulty of law enforcement officers. It's a unique profession. I recommend.
The member from the 7th District, Representative Maycomber.
Thank you, Mr. Speaker. I appreciate being here. You and I have worked on a couple bills. This bill is coming forward. Mr. Speaker, we need more diversity in law enforcement. Yes, we do. We have worked on that. We need more officers on the streets. Yes, we do. We have worked on that as a legislative body. We need to get those law enforcement officers whose hearts aren't in for service, who we've talked about before, who are not meant to serve our communities. We want them out. Yes, we do. But Mr. Speaker, what we are creating here in this bill may actually result in exactly what we don't want. When you are 50th in the nation for law enforcement officers per capita, you have what's called reactionary policing. And what happens is when you don't create an environment where the service-oriented hearts want to serve their community because of the liability, because of the danger, because of the risk to their families, to the risk of what could happen to them, and you create this perfect storm, you are less likely to get people into the field. And so what you're doing is you're almost creating the problem for which you're trying to prevent. And so, Mr. Speaker, when we look at policies like that, this weakens the collective bargaining agreements. That weakens the union rights, that weakens the law enforcement officer's ability to have an arbitrator, to go through a system and not have a citizen commission that has not served and not been trained, make ruling decisions on officers that are split second. Those moments, Mr. Speaker, create an environment of officers who may not be willing to serve their community with their heart. Mr. Speaker, Washington State has failed to support the law enforcement officers. Washington State has failed and become 50th in the nation of law enforcement officers per capita. We are in reactionary policing mode. Officers should be playing basketballs with kids. Officers should be helping community members. We are now just going to call to call to call. It's in a dangerous state. And now we are going to take their protections from them. All because we're trying to get out a couple bad actors.
The lady has 30 seconds remaining. Please conclude.
These are the people that will stand in front of us and lay down their life and not go see their children. We have to protect them too, Mr. Speaker. And then we have to create a work environment where they just don't collect their paycheck at the end of the day, Mr. Speaker, where they can serve their community and they can be protected, Mr. Speaker. Let's vote no on this bill.
The member from the 41st District, Representative Tai.
Thank you, Mr. Speaker. Mr. Speaker, I have the privilege to work with you and to meet with many law enforcement officers and the organizations that providing the support, the training for our peace officers throughout the interim. I will echo what representative from the 45th District have mentioned. And I too share that values. I honor police officer. Without them, my community is not protected. At the same time, Mr. Speaker, I can't help but share with you and this chamber the story of one of my communities. Just one, there are many, just one that has been in the news lately. And I'm gonna name him so that we don't forget. It's Tommy Lay. I don't need to spend the next 3 minutes to tell you the story of how Tommy died. I don't plan to spend the next 3 minutes to tell you the pain of the parents who would dress up the next day to go and celebrate his graduation from high school, yet dressed up to go to his funeral. I ask you, Mr. Speaker, what happened to the police officer who took the life of Tommy Lace away? Mr. Speaker, when only around 13% of our officers who are fired are being decertified, we have a problem. When the officers who are out there and their job is to protect us, and we are grateful for their work every day.
The lady has 30 seconds remaining. Please conclude.
Thank you. I believe, Mr. Speaker, that being accountable, that is the only way law enforcement force can build trust with the community that they are serving. This bill is about accountability. Vote yes.
The member from the 35th District, Representative Griffey.
Thank you, Mr. Speaker. I agree with the good gentleman from the 45th District that problems in law enforcement, those men and women that serve there, are few and far between, especially in Washington State. We do a very good job. And I do also agree with the good gentlelady that that we need to remove those that don't have the heart for service from the profession. We need to take a scalpel to this problem. Mr. Speaker, if you will, I would like every attorney in the room to think about this. What if we presented a bill to everyone in the room that reorganized the Bar Association that said the makeup of the Bar Association shall not now be from the public? It also must have 3 members on the Bar Association that's gonna decide whether you work or not, that have won a legal judgment against a law firm or an attorney. Mr. Speaker, that is what we're talking about here. We're taking a chainsaw to a problem that really does need a scalpel. We should respect the men and women in law enforcement enough, just as much as we respect those men and women that serve as our attorneys out there that are certified by the Bar Association, to understand that that is the wrong way to do it. It's taking a chainsaw to a problem instead of taking a scalpel to a problem. Please vote no on this bill, Mr. Speaker. We could do better.
Further remarks? The member from the 2nd District, Representative Wilcox.
Thank you, Mr. Speaker. There's a lot of responsibilities that go with our job. We all feel concern for our communities. We feel concern for the people that serve our communities. And I would imagine that many of the people that have served for a number of years here can remember one of the most painful things that you do in this job, and that's going to funerals. And it seems like my part of the state has more of those than we deserve. A year before I was first elected, 4 police officers from Lakewood were killed in one coffee shop. A year later, officer who patrols alone in rural Pierce County was killed close to Eatonville. A few years later, a young woman who was a dedicated park ranger tried to stop a fugitive, and she was killed. And a couple of years ago, a young man was on duty. He was someone who exercised. My dad, in his early 80s, did CrossFit with cops. And that young man was killed. Some of you have been to the Behind the Badge ball. and it's full of young people. It's almost like going to a prom if you're as old as I am. I love those people. They were getting away, enjoying themselves. They weren't all young, but a lot of them were. We left a little bit early, maybe 9 or 10 o'clock. And an hour after we left, everyone at that ball, all of them police officers and their significant others, found out that one of their number was killed on a lonely street in Lewis County. That's the ultimate accountability. People that put on the badge and wear the uniform are accountable for a lot.
The member has 30 seconds remaining. Please conclude.
I am 100% sure that next year and for many years after that, we're going to be back here dealing with the next crisis that these bills, which are necessary but go too far, are creating by making it even harder to fill that important job.
The member from the 30th District, Representative Johnson.
Thank you, Mr. Speaker. Closing debate for our side, I want to take a slightly different approach in my remarks here. Without a doubt, one must be called to a higher purpose to be a law enforcement officer. This session, I've heard a lot about the law enforcement policy changing too quickly or too vastly, that policing is changing in ways that folks did not sign up for, didn't expect, or don't know what to do with. But Mr. Speaker, the reality is our system of law enforcement can be a greater system as a result of policies like the ones before us tonight. The reality is we can actually encourage more people in our communities to want to be law enforcement officers if we pass bills like this, because they see the ability for our system to adjust, to adapt, and to improve. What we're experiencing today in 2021 is many in the community demanding a significant change in exactly how police are held accountable across ethnicities, across gender, sexual orientation, and so on. Because too many times police misconduct goes unaccounted for. Too many times officers continue in their jobs or jump to another jurisdiction without retraining, without discipline, or without real consequences. And I don't think we can truly understand how re-traumatizing or re-triggering it is to see the very officer that may have harmed you or a loved one right back patrolling the streets. Families like of my Chance Dunlap Gittens, who testified on behalf of one of my bills this session, and yet saw the very officer that killed their son testifying against that very bill. This bill before us tonight will bring the real accountability and oversight that is needed to the certification of law enforcement in this state. And we have an entire community and an entire generation watching exactly how lawmakers respond to this call, urging a yes vote.
Further remarks? Seeing none, the question for the House is final passage of engrossed second substitute Senate Bill 5051 as amended by the House. Do the whips need to excuse members? Seeing none, the Speaker is about to open the roll call machine. The Speaker has opened the roll call machine. Has every member voted? How does Representative Chop vote? Representative Santos? Representative Gregerson? Representative Gaynor? Representative Chop? Representative Gregerson? Representative Gaynor? Would Representative Chop like to vote orally, please? Would Representative Chop like to vote orally, please? Does any member wish to change their vote? The Speaker is about to lock the roll call machine. The Speaker has locked the roll call machine. Clerk will take the record, please.
Mr. Speaker, there are 54 yeas, 43 nays, 1 excused.
Having received the constitutional majority, engrossed second substitute Senate Bill 5051 as amended by the House is declared passed.